Thanks very much, Romany. And welcome everybody to this latest in the series of EWV commercial property updates. I'm Richard Van Jones. I'm a senior associate in the commercial property team, and I'll be discussing the Building Safety Act, and then we'll follow up with Phil Shepherd, who will be filling you in on concrete, and Ella Evans will bring proceedings to a close with a case law update. Before we crack on as well, I've just been asked to reiterate the invitation to you all to our commercial property Christmas drinks in our London office, which hopefully you've already been invited to. The invite will be attached to a follow-up email. It's on the 7th of December, and we do hope as many of you as possible can make it along. So without further ado, next slide, please. And next slide, please. So this is what we'll be cantering through. As you all know, this is an enormous act. So we'll be scratching the surface and discussing a few select points, but it's quite a lot to get to grips with, and I'm sure we're all very aware of it. Next slide, please. So to introduce, we'll go through a bit of background to the Act. It was a reaction to the Grenfell Tower tragedy of 2017, in which a fire broke out and rapidly spread throughout the 24-story block of flats. The Hackett report on building a safer future after Grenfell was published in May 2018 and concluded that the current system of building regulation and fire safety is not fit for purpose, and that a culture change is required to support the delivery of buildings that are safe both now and in the future. Subsequently, the Building Safety Act 2022 was introduced into Parliament on the 5th of May 2021. Its primary purpose is to secure the safety of tenants and occupiers of all buildings, though there are special provisions relating to high-rise blocks. It's an enormous piece of legislation. It's comprised of 262 pages, and it has been described by RAAC as the most comprehensive piece of legislation to hit the built environment in decades. Inevitably, we'll only be able to concentrate on a few issues arising under the Act during today's talk, and it is very much a work in progress, which will be subject to a great deal of clarifying regulations and case law over the coming years, as the courts seek to interpret it and apply the terms of the Act to the real world. Next slide, please. So the Act has a great impact on limitation periods. The limitation periods available affecting claims against persons responsible for defects in buildings under the Defective Premises Act 1972, which is the previous regime, have been greatly extended under the Building Safety Act 2022. Previously, there was a 6-year period, and this has been increased to 30 years for defective works carried out during the 30-year period prior to 28 June 2022, so 27 June 1992, and 15 years for defective works carried out after the 28th of June 2022. The effect of these extensions is retrospective, and this means that historic claims that were once statute barred may now be viable, and we may well see a raft of claims that until recently were unexpected or believed to have been time barred. Now, there are two limited safeguards available for defendants. The first is that a claim could be dismissed if it breaches a defendant's human rights. And the most obvious example here would be the right to a fair trial if evidence was unavailable due to the long period of time between the alleged defective act and the claim. But to date, we have no reported case law where a human rights defense has been successfully raised. And as you can appreciate, it's a pretty broad church. And the second is that the changes do not apply to any claim which was previously settled or subject to final determination by a court or arbitrator. So claimants can't come back after a second bite of the cherry if it's already been considered and adjudicated. If the company responsible for the defect no longer exists, the High Court can now grant a building liability order that can transfer liability to other companies within the company's group or even associated with the responsible company. So it's broader than a group company under the Traditional Companies Act definition, even if they had no involvement in the original build. The purpose of this is to pierce the corporate veil and prevent companies from being able to evade liability for making good defects by the use of SPVs or other corporate structures. The court can make an order when it considers it just and equitable to do so. It remains to be seen just how remote a company needs to be from the original offending company before it cannot be subject to a building liability order. And again, case law inevitably will follow to clarify this. Note that claims may now relate to refurbishment and rectification works and are not limited to defects in the original construction, as was previously the case. Next slide, please. So moving on to building regulations, the Act implements Section 38 of the Building Act 1984, and this has the effect of allowing anyone suffering loss as a consequence of building regulations breaches to claim damages for personal injury, including mental distress and damage to property. This change came into force on the 28th of June 2022, but it does not have retrospective effect. There will be a 15-year limitation period for claims. Moving on to the, building safety regulator. And the following came into force in England on the 1st of October 2023. The Act introduced the building safety regulator, which is established as a division of the Health and Safety Executive, and it was in order to implement the new building control regime for all buildings, to become the regulatory body responsible for building control in relation to higher risk buildings. Now, these are the buildings very much, or the category of higher risk buildings is very much Grenfell driven. So they're buildings which contain at least 2 dwellings and are 18 meters or more in height, or comprised of 7 or more stories. That's the settled definition in England. In Wales, it has not yet been finalised, but it is expected to be the same, although there is talk and expectation that in Wales, it might apply if there is only 1 dwelling within the higher risk building. There's currently a lead-in period, so if building work was started before the 1st of October 2023, the developer has 6 months in which to complete, and if they do, will be within the old building control regime. Other purposes for the building safety regulator are to oversee the safety and performance of all buildings, and to introduce and oversee a regulatory regime for building control professionals, and to exercise wide-ranging enforcement powers to enforce obligations and prosecute offences under the Act. The enforcement powers include fines for non-compliance, giving a notice to a property owner to alter or remove non-compliant works at any time within up to 10 years, and during the carrying out of works, to give notices requiring non-compliant work to be rectified by a certain date, and for all work on site to be stopped until non-compliance has been resolved. The building safety regulator has extensive powers available to it in the event of non-compliance with its notices. It is a criminal offence punishable by fine or imprisonment to commence work without having given an initial notice or a commencement notice, or to carry on or commence work following a rejection notice, unless the person carrying out the construction work is satisfied that the reasons for the rejection have been resolved. So we can see that the changes brought about by the Act greatly increase the severity of failing to comply with the regime requirements. Next slide, please. Moving on to leaseholder protections. After the Grenfell tragedy, there were many stories in the press of tenants being presented with astronomical quotes from landlords for remediation works to external cladding on tower blocks. And one of the key purposes of the Act is to protect tenants from any costs associated with removing dangerous cladding. The basic principle is that qualifying leaseholders should be protected from the often very high costs of remediating historic building safety defects. As long as a tenant has a qualifying lease, then, subject to various statutory criteria, it will not be charged for cladding works and will benefit from either a total exemption from liability for the cost of other necessary safety works, depending on the value of the property, or a cap on the amount that the landlord can recover from the tenant. Next slide, please. The leaseholder protections are set out in Part 5 and Schedule 8 of the Act and apply where a relevant building is found to have relevant defects that require remediation, the cost of which the landlord would normally seek to recover from its tenants via the service charge, but for the protection of the Act. So a relevant building must be at least 11 meters or 5 stories in height and contain at least 2 dwellings. Relevant defects are defects that put a person's safety at risk from fire or structural collapse, arise from work done to a building, including the use of defective products, either during initial construction or later refurbishment or remediation works, and which have been created in the period from 28 June 1992 to 27 June 2022, so 30-year limitation period. The cap on service charges for dealing with relevant defects in relevant buildings is set out in the Act and provides there's a maximum charge for qualifying leaseholders of £10,000 per flat, or 15,000 in London, per 10-year period. And that's a total, 10,000 over that 10 years, not 10,000 per year. If the flat in question is worth less than £175,000, or 325,000 in London, as at the 14th of February 2022, then no service charge is payable in relation to safety works. So who is a qualifying tenant? For the purposes of the Act, the key date is the 14th of February 2022. Now, government guidance online says that this was chosen as a line in the sand to prevent developers from gaming the system, but it does mean that everything goes back to that date. In order to be a qualifying lease benefiting from the protection of service charge exemptions and caps under the Act, the following criteria must all be met. So the lease must be of a flat in a relevant building, so at least 11 meters or 5 stories high. It must have been granted before the 14th of February 2022. It must be a long lease, by which they mean a term of more than 21 years. There must be a service charge reserved by the lease. And on the 14th of February 2022, the flat must have been the tenant's only or main home, or the tenant did not own more than 3 dwellings in the United Kingdom. Now, this is a bit of a tricky one. The government guidance online gives multiple examples designed to illustrate how this particular requirement is to be applied. It's well worth a look. I will read you out just a couple. So the first example they give is perhaps the most straightforward. It's you own a long lease, which has been granted before the 14th of February 2022 within a relevant building in England. This is your only or main home. You qualify for the leaseholder protections. That's fairly straightforward. The next one is you own 4 flats in England within relevant buildings. You do not own any other property. you live and lived on the 14th of February 2022 in one of these flats. In that situation, only the flat lease that you live in qualifies for the leaseholder protections. The other flat leases do not qualify, as you own more than 3 properties in the United Kingdom. But if you owned 3 in total, including the one that you live in, then all 3 would benefit from the protection. So if all of the conditions applied on the 14th of February 2022, then the lease is a qualifying lease forever, even if the circumstances of ownership subsequently change. So for example, a tenant sells to a third party who owns 50 dwellings. In the UK, that lease remains a protected tenancy. But the opposite also applies. So an individual acquiring a flat in a relevant building to be their sole residence will not benefit from the service charge limitations in the Act if the lease was not a qualifying lease on the 14th of February 2022. Now, this has the ability to blight the status of a lease for the rest of its term and is likely to affect the mortgageability and the saleability of such properties, or at the very least, the price. Next slide, please. Another anomaly contained within the Act is in connection with lease extensions. The Act as drafted would appear to exclude once qualifying leases that are subsequently extended under the Leasehold Reform, Housing and Urban Development Act 1993. This is because extended leases, from a legal perspective, count as surrenders and regrants, and so any lease extended in this way would not fulfill the requirement that it was in existence before the 14th of February 2022. This has been a matter of great concern to tenants and conveyancers, but has now been addressed by Section 243 of the Levelling Up and Regeneration Act 2023. This confirms that such leases will be known as connected replacement leases and will benefit from the tenants' protections in the 2022 Act. The provisions of the 2023 Act will have retrospective effect, so there's no gap between the two acts during which extended leases might lose their protected status. And this Act received royal assent very recently on the 26th of October 2023. And moving on to the landlord certificate, which is a requirement that needs to be served by the landlord upon tenants if the landlord is to be able to recover the cost of carrying out works to defects. Now, under the 2022 Act, if a landlord does not provide a certificate to a tenant, it will not be able to recover via service charge any costs incurred in connection with safety work carried out of the building. In the recent case of Will and Coturba and G&O Properties Limited, the developer had gone into liquidation after carrying out remediation works for which no landlord certificate had been provided, in spite of the tenants, Will and Coturba, repeated requests. The landlord refused to provide a landlord certificate, so the tenants applied to the first tier tribunal for a declaration forcing them to do so, as they were concerned that they would have difficulty selling the flat without the certificate. The certificate would have provided details of the works carried out and demonstrated whether the landlord was liable for them under the Building Safety Act 2022. The tribunal held that it did not have jurisdiction under the relevant regulations to require a landlord to provide a landlord certificate. Although non-provision would mean that the landlord could not charge any part of the cost of the works related to the relevant defects to the tenants, the regulations themselves did not empower the tribunal to force a landlord to provide a certificate. It's worth noting, though, that in its decision, the tribunal suggested that this was an unintentional omission within the regulations. Schedule 8 of the 2022 Act authorises the making of regulations in relation to a landlord certificate, and this does seem a glaring omission. So it's quite possible that future regulations may change the position and empower the tribunal to force landlords to issue landlord certificates. Next slide, please. So just moving on to one or two other issues arising as a result of the Act. The first is lenders' requirements. The Lenders' Handbook has been updated to include additional requirements for building safety information. This is confirmation as to whether the building has been or will be remediated under the Act, copies of any landlord certificates signed by the landlord in the required form, and copies of any executed leaseholder deed of certificate in the required form, plus confirmation they've been submitted to the landlord. Now, in addition to this, some lenders have their own more stringent requirements. For example, Barclays apparently requires the borrower solicitors to confirm that the borrower has fully understood the remediation schemes, and that is pretty much impossible to determine for a third party. Moving on to the other administrative burdens and reporting requirements, these are really ones that fall upon solicitors' shoulders, and I'm sure the non-solicitors among you will be entirely sympathetic. But for example, the standard inquiries have now been updated to deal with any issues arising under the Act, and there'll be additional documents that solicitors will be required to review, including the landlord certificate and the tenant's deed of certificate. It will be absolutely essential for professionals to understand the position under the Act and to report to clients accordingly. Well, thank you very much. That's a brief canter through some of the issues that arise under the Building Safety Act 2022. I'll now hand you over to my colleague Phil for the next talk. Thank you.
Thanks very much, Richard. Hello, everybody. I'm Phil. I'm a senior associate here at VWV, and I have the pleasure over the next 15 minutes or so to talk to you about reinforced aerated autoclaved concrete, which I'm going to call RAAC for the rest of the session because otherwise I run out of time every time I have to say it. Could we have the next slide, please? RAAC's been big over the last couple of months due to its presence in schools and the obvious political fallout that's arisen from that. But it is more broadly used and is more broadly applicable to commercial properties up and down the country. And it's therefore generating quite a lot of interest and quite a lot of panic also. So hopefully over the next 15 minutes, I will let you know whether you're the sort of person that needs to be worried about RAAC and perhaps some things to do about it. So I'm going to begin with a quick explanation about what RAAC is and why it's an issue. Then I'm going to turn to liability for third parties. That is to say, if the building collapses, who is it that might be liable to third parties who are injured? Then some landlord and tenant issues that we've seen recurring under RAAC. Then very briefly on some things to think about when buying, selling or leasing property that is or might contain RAAC. And then finally, the bit you're probably all here for, a practical approach for how to deal with it. Can I have the first slide? Next slide, please. So what is RAAC? It's a form of reinforced concrete, as the name suggests. It's easiest to think of it in respect of the cross-section that you can see at the bottom. So it is steel rebar that is then surrounded by bubbly concrete, think of an aero bar, which is itself then surrounded by a hard outer shell. Now, the beauty of this is that it is very, very light, which means you can get very long spans out of it, much longer than you would be able to get with normal, traditional reinforced solid concrete. And that made it really popular in the 50s through to the 70s, and it was also used in the 80s and 90s as well. Not as popular anymore, thankfully. But the greatest advantage of it, this aerated nature, is also the biggest weakness that it has, because it is particularly susceptible to water penetration. So if that hard outer shell is compromised in any way through general wear and tear, a jobbing contractor putting a bolt through it to attach some M&E, whatever it might be, water will penetrate into the aerated concrete. It will rust and corrode the steel in the middle. The steel will fail, and the entire bar will sag and will eventually snap. There's nothing wrong inherently in RAAC. It's a wonderful material, I'm sure, but it does have a very limited design life. And due to the age of the buildings in which it was used, though that design life, which is about 30 years, is now well and truly come and gone. And so RAAC is generally, where it's to be found, often in disrepair. Can we have the next slide, please? So very briefly, there's probably three categories of people that need to be concerned about RAAC in their estate, and those are occupiers, employers, and landlords. Two of them are quite obvious, landlords perhaps less so. Occupiers, I'm sure you're aware, are responsible for the health and safety of people that come into their premises, and that includes invitees under the 1957 Act and non-invitees, typically call them trespassers, under the 1984 Act. And the obligation is to take reasonable steps to ensure the reasonable safety of invitees and to take reasonable steps to protect trespassers or non-invitees from hazards that one ought to be aware of and into the vicinity of which one might reasonably expect a trespasser to come. So it's a reasonable endeavours, reasonable steps requirement to take. Employers have a similar liability under the Health and Safety Act. They have to take all reasonable, so far as reasonably practicable, to ensure the health and safety of their employees and any third parties who might be affected by hazards in the undertaking. Any employer who fails in that duty will suffer or faces criminal liabilities, so fines and being put on the naughty list, which is of course reputationally damaging. The third group, landlords, is a bit less obvious and is often overlooked by some landlords who take a very hands-off approach to their estate, but it mustn't be overlooked. Under Section 4 of the Defective Premises Act, there are two ways that a landlord could be directly liable for injury to a third party. The first is where the landlord has undertaken to keep the property in repair. That's fairly straightforward. If the landlord has covenanted to keep the structure of the building in repair, they fail to do so and a third party is injured as a result, the third party can sue the landlord directly. Fairly straightforward. The second way that landlords can be liable is where the landlord has reserved the right to carry out repair work. They ought to have known that repair work was required. They could have carried out that repair work or put themselves in a position to exercise the right. They failed to do so and a third party is injured. So in many, many leases, the vast majority of commercial leases, there will be a right by the landlord to go in and carry out works to repair the property if the tenant fails to do so. Having that clause in there exposes a landlord to liability to third parties. If the landlord ought to have been aware that the building was in disrepair, could have served a notice on the tenant, could have gone in and done the works, but didn't, and a third party is injured, the third party can sue the landlord directly. So there is real incentive for landlords, even where they don't have an obligation to maintain, to check whether or not they might nevertheless be liable and need to sort out any RAAC in the building. And all three of those categories of people, occupiers, employers, and landlords, can also be criminally liable for manslaughter or corporate manslaughter. The most obvious example is gross negligence. If the responsible person falls well below the standard that is required of them and a person is killed as a result, then they may face a manslaughter charge. So it is a serious thing that needs to be taken into account. And at the end of this, I will come back to how best to discharge all of these duties. Okay, the next slide, please. In respect of the landlord and tenant issues, the good news is there are no special rules for RAAC. This isn't like asbestos or fire safety where specific regimes apply. Responsibility for the maintenance of RAAC and remedying any RAAC that is in disrepair is a matter for the lease. any of your normal landlord and tenant approaches to any other form of disrepair will apply here. However, given the difficulty sometimes of inspecting RAAC and the cost of repairing it and the disruption that it can cause, landlords and tenants sometimes don't always see eye to eye in terms of who should be doing what, and that can cause issues. Now, 3 issues that do come up. The first is a failure to inspect. Both landlords and tenants can be inclined, perhaps, to turn a blind eye to whether or not they need to be inspecting for RAAC, and that's obviously not good enough. If the tenant fails to inspect for RAAC, then the landlord can usually go in under the lease. It's usually a reservation for the landlord to go in and carry out an inspection itself, and then charge the tenant for the privilege, either under a service charge or standalone cost recovery clause. So landlords are usually pretty well protected if a tenant doesn't inspect for RAAC. The same is not true the other way around. There is not normally a corresponding obligation on landlords to inspect, or for right for tenants to go in and inspect where a landlord hasn't done so. In that situation, if you're a tenant and your landlord has a repairing obligation but doesn't seem to be inspecting, turning a blind eye to it, what you may be able to do is, first of all, in trying to treat the landlord, explain to the landlord that they may be liable for the reasons set out in the previous slide, and that it is in everybody's interests to inspect for RAAC. Alternatively, in those circumstances, a tenant may wish to take the extrajudicial approach and to carry out the inspections themselves. Obviously, doing so may be a trespass to the common areas. It may require opening up that need to be made good. However, as long as the tenant does make good, it may well be easier to ask for forgiveness for that than it will be to try and explain why employees' health and safety has been put at risk. Not an ideal situation, unfortunately. The second recurring issue is a failure to repair. Again, if a tenant fails to repair, a landlord normally has a right of entry to go in to carry out the repairs and to recharge those costs to the tenant. If the landlord doesn't have that right or doesn't want to use that right, the landlord might be able to seek an injunction against the tenant to require them to maintain the property. And that's not normally done in respect of disrepair, and it would have to be a pretty serious situation that would justify an injunction to carry out repairs. Probably one that either exposes the landlord to liability if the repairs aren't carried out, or that may threaten the value of the reversion itself. Otherwise, it's not really the landlord's problem. If the landlord fails to repair the structure, again, the tenant probably doesn't have a corresponding right to go and do the works itself, but the tenant can entreat the landlord to carry out the works, see above, or could, again, seek an injunction against the landlord to carry out the repairs. Again, not an ideal situation. And the third recurring issue is one of nuisance and of quiet enjoyment. Both landlord and tenant will normally have given not mirrored but fairly similar undertakings to one another under the leases, not to cause too much annoyance to one another. Of course, carrying out inspections, carrying out works are typically disruptive. The right to go in will normally, or obligation to repair, will normally trump the nuisance clause, but it is not a blank check. So if you have covenanted not to cause nuisance or annoyance to anybody else, it's always best to speak to them first, explain what works are going ahead, understand their particular sensitivities, offer a timetable of work, stick to the timetable of works, let them know if there's anything particularly disruptive or noisy that's about to take place so that they can plan around it. If you don't do that, there is a risk, notwithstanding your obligations to maintain and repair, that you may be found to be in breach of those covenants. Could I have the next slide, please? This slide, very, very briefly, is just some things to think about when you're buying, selling, or letting. I'm sure many of us here are aware of the commercial property standard inquiries. inquiries that are sent to the seller or to the prospective landlord that they're supposed to fill in, respond to, and send back to the buyer or prospective tenant solicitors. Any inaccuracy in those responses exposes the representor to potential liability for misrepresentation, and it will allow the other party to rescind the contract or claim damages. So it's really important that you answer those questions correctly. Now, questions 8.1 and 8.6 I've highlighted on the screen, which are questions regarding structural or inherent defects or unstable, hazardous, or unsuitable materials in the structure. Strictly speaking, if you ask those questions and you get the answer back no to them, that is not an indication that there is no RAAC in the building. RAAC is not inherently defective. It's a fine building material. It's just well past its use by date by now. And therefore, if you receive the answer no to those two questions, I wouldn't rely on that for identifying RAAC. If you need to know about RAAC being in the building, ask a direct question about it. And see what answer you get back. If you're answering the question on the flip side, and because I'm a lawyer, I'm going to be being overly cautious, in order to avoid any accusations of misrepresentations, be very clear if you're answering questions 8.1 and 8.6 whether or not you're talking about RAAC, because the person you're answering to might think you're representing that there is no RAAC in the building, notwithstanding that it doesn't, strictly speaking, fit into those questions. Also, just be very careful about answering questions with the answer no, or not to my knowledge, or I don't know. Those sorts of answers can still get you into trouble if it turns out you did know, you just forgotten, or you ought to have known. And we see that from recent Japanese knotweed cases, actually, where somebody said that there was no knotweed to his knowledge, and it turns out that in evidence he ought to have known that there was some there. So just be very, very careful in those answers when you give them, and be perhaps very skeptical of answers that you receive. Could I have the next slide, please? So this is it, the final slide, which is the practical approach. What are you supposed to do if you are a landlord or a tenant or an occupier employer and so on that has RAAC or suspects there might be RAAC in the building? What are you supposed to do? Well, fortunately, the Institute of Structural Engineers and the Health and Safety Executive have both provided guidance on the correct approach so far as they see it. They differ very slightly, but they can be synthesized together. They basically follow the same approach. Now, the advantage of having this sort of guidance is that if you follow it and you follow it well, it makes it so much easier to say that you did exercise reasonable care as required under the tests that I set out on one of the slides much earlier. So what is that approach? First of all, identify if there's any RAAC. The Institute of Structural Engineers says that you do not need to be an expert in concrete to identify whether there is any RAAC. And the Department for Education has circulated a helpful guide on things you can look for to determine whether or not RAAC is in the building. Things like the age of the building, flat roofs, things like that, which will be very useful in identifying whether there is any RAAC. Of course, I appreciate that not everybody wants to be the one person who signs off to say, no, there definitely isn't any, in which case the Institute of Structural Engineers has a section on its website for structural engineers that it recommends, that it says no about RAAC. And if you instruct one of those, they will be able to come around and tell you whether or not there is any RAAC in your building. If you've identified that there is RAAC in the building, you then need to assess it. You need to work out what state of repair it is in. Although the design life has long since expired, there is RAAC that is perfectly fine. There is some RAAC that is in a perilous situation. A structural engineer will be able to assess that and determine what state it is in. And in light of that report, that assessment, one can then start to manage the risk. The engineer will be able to provide you with recommendations, and those recommendations may be, this building is in a disastrous state of repair, you need to leave immediately. It may be that this RAAC is fine. in which case you just need to continue to monitor it. And if you detect anything, any cracking, anything like that, then we reinspect. It is not necessarily the case that all RAAC in a building is in terrible state and that every building containing RAAC needs to be evacuated. That's simply not the case. In addition, there is sector-specific guidance because different sectors have different requirements. For example, RAAC is found in healthcare settings as well, and it can be particularly difficult to suddenly say you're going to close an entire hospital. It's not realistic. So if you are in a sector that has a particularly active regulator or other professional body that can provide advice, I would have a look on their website and see if you can see what guidance there is. There is, for example, already guidance issued for local authorities, for healthcare, and for education. Those all exist. If those exist, bear those in mind as well. And as long as you follow that guidance, you create a paper trail, your risk assessment reflects the guidance, you take professional advice at the assessment and management stage and at the identification stage if you need it, then you will be going a very long way to A, avoiding anything catastrophic happening, and B, if anything catastrophic does happen, avoiding liability by showing that you exercised all of the care that you were expected to take. Hopefully that has not scared anybody too much and has given everybody a little bit of comfort that it's not as disastrous as the news would have us believe. If you have any questions, please pop them in the Q&A and we'll get to them at the end. Otherwise, I shall hand over to Ella Evans with our case update.
Thanks, Phil. Good afternoon. I'm Ella Evans and I'm an associate in our commercial property team. The cases I'll be discussing today highlight the importance of active estate management and taking action at the right time. The first case I wanted to discuss is a case of Avondale Park Limited v Miss Delaney's Nursery Schools Limited. As we are aware, when negotiating a new commercial lease, there are certain provisions which will need to be agreed between the landlord and tenant. One fundamental point is whether or not security of tenure will be given to the tenant, or whether the lease will be contracted out of the Landlord and Tenant Act 1954. Part 2 of the Landlord and Tenant Act 1954 provides that a commercial lease will automatically have security of tenure. Security of tenure means that the tenant will have the statutory right to renew their lease at the end of the lease term. The landlord can oppose any renewal, but only on limited grounds. The landlord and tenant can agree that a new lease will be contracted out of the Landlord and Tenant Act 1954. By contracting out the commercial lease, the tenant will lose their right to security of tenure. Whether or not the commercial lease is to be contracted out is a commercial point for the parties to agree on. The facts of the case are the landlord, which in this instance is Avondale Park Limited, was granted a lease of residential property by the freeholder in 2014, which was due to expire on the 13th of September 2022. The lease was granted with security of tenure. The permitted use under the lease was for residential accommodation. The landlord subsequently granted a sublease to the tenant, which was Miss Delaney's Nursery Schools Limited, on the 9th of September 2014, which was due to expire on the 29th of August 2022, and had been contracted out of the Landlord and Tenant Act 1954. The sublease included a clause which provided that the lease would automatically terminate if the landlord did not provide a deed of variation to the tenant by the 14th of December 2014, stating that the freeholder had granted consent to the change of use of the property from residential use to nursery use. The key point here is that no deed of variation was provided. The tenant, however, took occupation of the property in late 2014, spent a considerable sum refurbishing the property as a nursery, paid the rent, and traded as a nursery until August 2022. The landlord was fully aware of the tenant being in occupation and had been accepting the rent. Issues arose on the 26th of August 2022, shortly before the start of a new school term due to non-payment of rent, and the landlord tried to take steps to forfeit the lease by re-entering the property. The tenant was granted an injunction and so had possession of the property for the start of the school term. The landlord contended that the sublease had expired by the time the injunction hearing took place and therefore should not have been granted. The tenant argued that because no deed of variation was provided by the 14th of December 2014, the sublease could automatically terminated, and the tenant's occupation since the 14th of December 2014 was under a periodic tenancy protected by the Landlord and Tenant Act 1954. The landlord appealed the decision to the Court of Appeal, stating that the effect of the clause was not to automatically terminate the lease. However, the Court of Appeal rejected this and stated that the language of the termination clause in the sublease made it plain that the lease was to be terminated if no deed of variation was provided by the 14th of December 2014. The landlord also appealed on the grounds that an estoppel by convention had arisen, which would prevent the tenants from asserting that it occupied the property under anything other than the sublease. Again, the Court of Appeal rejected this on the basis that the continued occupation and continued payment of rent was consistent with the existence of a periodic tenancy which would grant security of tenure. This case demonstrates the importance of considering how a tenant occupies a property following the lease term coming to an end. Although the clause used in this particular sublease is not common, landlords and their agents are advised to keep a full log of the expiry of any leases as part of their estate management, and to ensure that action is taken in advance of the end of the lease term. The tenant should not be allowed to remain in occupation following termination of the lease term without any steps being taken to avoid a periodic tenancy arising. Next slide, please. The second case I wanted to discuss was the recent case of Sunset Limited and Another v Al Hindi. It is becoming more common for registered offices of landlords to be outside of England and Wales. Landlords therefore do need to ensure that their address for service is located within England and Wales, and to ensure that any change in detail is notified to the tenant. Section 48 of the Landlord and Tenant Act 1987 requires that a landlord of a property must provide to their tenant an address for service in England and Wales. Failure to properly comply would mean any rent, service charge, or administration charge due from the tenant to a landlord will not be deemed due, despite being demanded, until the landlord has provided the necessary address for service. In this case, Sunset Limited, who is the landlord, filed a bankruptcy petition in respect of Mr. Al Hindi, who is the tenant, in June 2022. The petition was based on the tenant's failure to comply with statutory demands from March 2022 relating to an unpaid debt of £248,750 in relation to rent which was due under 4 leases of properties in London. The tenant argued that the landlord had not complied with Section 48 of the Landlord and Tenant Act 1987, as the address for service contained in their tenancy agreement was an address in Jersey, and that they were only given an address in England by the landlord in February 2023, and therefore claimed that no rent was due before that date. Although the landlord claimed they had complied with Section 48 on the basis that they had included an address in England and Wales on the statutory demands to the tenant back in April 22, the court did not accept this on the basis that the address located in England given in the statutory demand was for their solicitor, who expressly stated it was to be used for communications about the demand. The court therefore found that the landlord's petition for recovery of the rent arrears must be dismissed. The key takeaway from this case is that the landlords or their agents must comply with Section 48 of the Landlord and Tenant Act 1987 and ensure that the tenant is made aware of any change in circumstances as soon as possible, or they could find themselves being unable to claim unpaid rent or other payments from the tenant. Next slide, please. The last case I wanted to summarise today was one highlighting the importance for a landlord to be able to forfeit a commercial property. The ability to forfeit a lease enables a landlord to re-enter the property following a breach of the tenant covenants in the lease. When a landlord re-enters a property, the lease is terminated. To be able to forfeit a lease, the landlord will be required to establish the right of doing so under either of the following instances. Number one, where a tenant is in breach of any of its obligations in the lease, or number two, on the occurrence of certain events specified in a lease, such as insolvency. The case of Chugg v Dallywell considers the circumstances where a tenant is prevented from challenging the lawfulness of a landlord forfeiting a lease. The facts of this case are that the landlord, Mr. and Mrs. Dallywell, were the freehold owners of a property in Hounslow. The landlord granted a 10-year lease of the property to a tenant in 2005, who was Mr. Chugg, who operated a homeware shop out of the property. The lease contained a restriction on the tenant not to part with possession of the property or to allow any other party to occupy the whole or any part of the property. In late 2016, the tenant sold his homeware shop business to a third party, Mr. Dawan, who continued to run the shop as the Essential Homewares Limited. However, the tenant never assigned the lease and the landlord had not been notified that the third party, Essential Homewares Limited, had taken occupation, and the landlord had not given any consent to an assignment. Essential Homewares took occupation of the property and paid the same rent reserved by the lease to the tenant to the landlord. In January 2019, the landlord became aware that the property was occupied by Essential Homewares. In December 2018, a payment of rent had been missed and also another issue had arisen relating to an alleged unlawful alteration at the property. The landlord continued to accept payment of the rent from January 2019 to April 2019. On the 5th of July 2019, on the realisation that the property was now occupied by Essential Homewares and not the original tenant, the landlord served a notice under Section 146 of the Law Property Act 1925 to forfeit the lease, citing arrears of rent and breach of the alienation clause in the lease. The landlord, assisted by bailiffs, peacefully re-entered the property and therefore forfeited the lease. However, on the 9th of July 2019, the original tenant wrote to the landlord stating that he understood that it was his responsibility to put the property into a state that it was at the time of the lease, and that they would be making an application for consent in respect of occupation of a third party, Essential Homewares. Discussions between the landlord and the original tenant were ongoing, and the original tenant informed the landlord that he would accept the forfeiture if the landlord would waive any further claims in respect of the property, and the landlord would not pursue a claim for any dilapidations. The landlord was unable to agree terms of a new lease with a third party, and therefore re-entered the property again and took possession from Essential Homewares. Both the original tenant and Essential Homewares issued proceedings against the landlord to state that the first re-entry had been unlawful, or alternatively free from relief from forfeiture. The claims were rejected and they appealed to the High Court, who found that the original tenant had accepted the forfeiture to the lease and relinquished any further interest in the property in return for the landlord agreeing not to pursue him for dilapidations. The decision in this case highlights the importance of the landlord's right to forfeit a lease, but also shows that the right of forfeiture is not a simple one. It also demonstrates the importance of active and vigilant estate management and to know who is the tenant of the property at any particular time. This is particularly the case for landlords with portfolios of property. That concludes my case update for today. We'll now move on to our question and answer session.
Thank you, Ella. I see we have 3 questions already. If anybody else has any other questions, please feel free to pop them in the Q&A. 2 of those questions are, I think, for me to answer. So I'll perhaps begin with those. I don't know whether you can see the questions that have been asked, but I'll read them out for the sake of the recording. The first is to say RAAC and nuisance or breach of quiet enjoyment. If a landlord has a repairing liability to remedy RAAC, and the only way to remedy the RAAC is for the tenant to decant from the premises so that the works can be undertaken, who is liable for the tenant's costs? The slightly hedged answer is it's going to depend what the lease says, but the broad answer is the tenant will be liable for those costs. because they are an incident of the repair that the landlord has reserved the right to carry out or the obligation to carry out. Now, there might be an argument that the if the RAAC is in really bad condition, that the amount of work that is now required is only a result of the landlord's previous failure to keep the concrete in repair, and that therefore that is a breach for which the landlord should be liable to the tenant. But assuming we're not at that stage, and let's assume that the concrete was in great condition and has only just got into bad condition and the landlord is being very proactive, but the only way nevertheless to deal with it is to throw the tenant out, then the tenant should be the one that ends up paying for the relocation and so on. Now, that's not to say that the landlord shouldn't try to accommodate the tenant in any case, if only to minimize or buy off the risk of a claim being made by the tenant. It is a good question. It's a really tricky point. And a lot of that is going to turn on exactly the facts leading up to the necessity of removing the tenant in order to carry out those works. I should say that doesn't bring the lease to an end either, by the way. Removing the tenant, they do have a right to go back in afterwards. So you can't simply throw the tenant out and say, we need to do the works, don't ever come back, because that's not how that works. Thank you for that. That's a very good question. The second RAAC-based question is: would a tenant be liable to would a tenant be able to disclaim liability for RAAC as an inherent defect, either during the lease term or under a dilapidations claim? And I think the answer is no. RAAC could have been installed defectively. It's certainly possible. If it's been installed in such a way that when it was first put in, it was never going to work. But by and large, RAAC is fine. The only reason it fails is because it's reached the end of its design life. And at the date that it was put in, there was nothing wrong with it. It wasn't defective in any way. Therefore, the tenant is going to be liable, if they've assumed responsibility for doing so, to keep that RAAC in repair, even if that means the wholesale replacement of it. Unfortunately, a tenant isn't going to be able to simply wash their hands of it. There could be arguments that a tenant could make. For example, if the tenant only has, a very short amount left on the lease, and we know that the works that are going to be required are going to be very extensive. They're going to make the building good for the next 30, 40 years. Then the tenant may have an argument that it is not a fair proportion, that there is significant betterment for the benefit of the landlord in so doing. So there may be a defence there, but generally speaking, the tenant isn't going to be able to get out of this by simply saying that the RAAC is defective. Thank you for that question as well. The third question, I think, is Richard.
That's me. Yep, that's from James. Thank you very much. So James says, if work started before the 1st of October 2023, is it correct that the contractor has 6 months to complete, or is it just to make a meaningful start on site, for example, piling? My understanding is that it has to be virtually completed, but I am happy to stand corrected on that. I think the building has to have made some pretty significant progress before the 1st of October. So I don't think just shoving a shovel into the ground, to preserve the planning or whatever would be sufficient. And essentially, it has to have been in the position where the local authority would have accepted an initial notice prior to the 1st of October. And then it has to be sufficiently progressed by the 6-month period after that. But hands in the air, it's a really good question, and I will do a bit more digging. I can't give you a definitive answer right now, but I think hopefully we've got James's email somewhere, so I'll do a bit of digging and see if there's definitive guidance on that particular point.
I don't think, unless there are any other questions. then I think that that concludes our update for you all today. Thank you very much for joining. As Richard kindly reminded at the start of the session, it'd be great to see as many of you as possible on the 7th of December for our Christmas drinks. The invite should be attached, if not already, to these slides and the recording when it comes around to you later on. You also have a feedback poll that should be on your screen now. Any and all comments, good or bad, are of course very welcome. Thank you again, and we hope to see you next time.
Thank you very much. Thanks, Phil.